Jerome Mayhew.
Thank you very much, Madam Deputy Speaker. I rise to support both of these proposed statutory instruments, but I'm going to speak in support of only one, and that's the liability of trade unions in proceedings in tort and the increase in the limit on damages. I think to set the context for this, we need to look at what the rights and obligations under the law of tort, the common law duty under tort, is, so that we can then understand the rationale behind these orders. As many members of this House will know, that for a duty or liability under tort to become established, you first of all have to have a duty of care for one organisation or individual to another. There needs to be a breach of that duty, and then evidence to demonstrate that that breach was in fact causative of damages, identified damages. Now, this is a standard part, the law of tort, of our common law, and it's worth making the point, Madam Deputy Speaker, that it applies to all of us in all of our relations, one with the other. It's not unique to the unions. And so the starting point is that every organisation is responsible in damages for a tortious breach of their duty of care. We now move to the specific problem with trade unions-inspired strikes. Because whilst the withdrawal of labour is a fundamental right, as the Honourable Lady made clear, it can lead to a huge number of breaches of tortious duty if that strike were illegal, because public sector work impacts so many other organisations. So the government in previous legislation has created an exemption for unions for legal strikes, the official protected industrial action clauses. But what about illegal strike action? Now, that is not protected under law, and so the risk remains that trade unions are open to crippling awards of damages. Now, why shouldn't they be? If they've caused, through their illegal actions, losses, identified losses to other individuals, why shouldn't they be responsible for them? I will give way.
The forgiving way. I just wondered if he could identify the last time there was an illegal strike, please. Thank you.
Well, since 1982, there has been effective legislation to dissuade this kind of act, but the effectiveness of that legislation has diminished over time to such a level that it's no longer worth applying it, because the level of the damages cap is so low in real terms that it's become ineffective as a disincentive. I will give way to...
Grateful to the honourable member for giving way. Just on that point, does he understand that actually, given that the normal remedy is an injunction, ironically, what he's proposing might make injunctions against strikes more difficult for employers to obtain? And that's because one of the conditions of the grant of an interlocutory emergency injunction is that it must be shown that damages, if awarded at full trial, would not be an adequate remedy. So by raising that remedy, it's actually less likely that an employer would be able to get an injunction, and therefore his argument has undermined itself.
Eventually, I fundamentally disagree, because as the honourable member will know, that when you're making an interlocutory application for injunction, you often have to give an undertaking in damages. And the cap that we're talking about, which I haven't yet come onto in my speech, will be raised not to a level that is new, but merely restoring what was put in place and what was the will of Parliament when this legislation was enacted back in 1982. So just moving on, there is a very strong argument that an organisation that causes loss to another through their breach of a duty of care should be responsible for 100% of those damages. But the government has not taken that view. They have they've moved to cap the liability and damages for trade unions, even when strikes are illegal, because the government has tried to balance a disincentive for illegal strike action, which I make no apology for, with the protection for trade unions from the full consequences of their actions, even though they might be illegal. And the reason why they do that is because the government is in favour of trade unions, and they do not want to have crippling damages awards to trade unions. So there is a balance of rights and obligations here, which, in my view, is absolutely reasonable. Now, that cap was set by Parliament in 1982 under the Employment Act of that year between £10,000 and £250,000 based on the size of the union and their ability to pay. Now, it seems quite wrong to me, Madam Deputy Speaker, that in all those 38 years intervening, those caps have not been increased by the price of inflation or any other amount. And so the balance between the rights of unions and the rights of damaged businesses and individuals has now, in my submission, become unbalanced. Now, there's no longer acting as legislation proposed, and we need, and I think the government is quite right, to take this action to rebalance as the original legislation required. Now, I looked up the inflation rate between January 82 and May 2022 on the ONS website for RPI figures, and the multiplier would be 4.31963 to be entirely accurate. Now, the government's proposals are actually a less than inflation rate of increase using a multiple of 4. So it's entirely right that the proposed orders restore the original intention of Parliament. Now, the legal right to strike is wholly protected, and it is disingenuous for members opposite to suggest in their speeches and their interventions that the right to strike is being in any way affected by these proposals. It merely restores the balance of rights between damages available to victims, and they are victims, of tortious losses caused by illegal strike action, and protection of trade unions from their crippling losses. And I think that's right. It's an incentive to avoid legal strikes, and I think that's a good thing. This is good government, Madam Deputy Speaker. I support the order and only suggest that the limits from now on rise automatically with inflation to avoid a repeat of this debate in 2060.